Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hi. I'm sorry I'm late. I'm not even finished getting dressed. You'll have to forgive me, but jump on into the pool as we entertain ourselves this evening, whichever way we see fit. I hope that you're good tonight. I am sort of good. I'm excited to see you guys. I've invited a special guest to our pool party, somebody who I think would be a blast. I've heard that he loves traveling to Florida to party and relax. And so, I quickly thought to myself, who could we invite tonight to the pool party other than, before I reveal who the special guest might be, thank you Cellulite Yoga Pants for reminding me. I'm sorry, that is quite the teaser, but don't worry. All the commands still work. There are so many. Tonight you will see quite a few, I would ponder, but you'll also notice that your points have been reset, rescinded, relegated to the past. The top list is no longer dominated. It is now up for grabs. That's right. We're not talking about YouTube daddy points. We are talking about KCC points. The gambling, the heists. None of y'all have any money. So, while we're partying at the pool party, perhaps Paisley would be so kind as to reward everybody who's going to be here by giving points, which is what I will be doing throughout this live stream. And remember, these are not YouTube daddy points. These are our points. You understand? So, as a reminder, on YouTube, you need to be chatting in order to be getting points. Otherwise, you're not being registered for that. But it's not like nonstop chat, but you need to be participating. Hi, John. Bill, I bet you would. I bet you would. Now, what can you do with the points? Absolutely nothing. Literally nothing. Some of you don't care about it. They're completely arbitrary. That remains. But some of you enjoy a few. Oh, look. Cellulite Yoga Pants off to a fucking start. Gambling all her points and winning. Oh my goodness gracious. Oh, am I naked? Oops. I guess we all are under our clothes, aren't we? But, yeah. I mean, I don't know. I thought that's what pool parties were. I brought the balloons. And myself. Anyways, let's go ahead. This is not a green screen thing. I'm not wearing a bathing suit. Now, YouTube Daddy doesn't want me to say that. Did I say that within the fucking first 5 minutes? God damn it. Is it getting hot in the West Coast again this week, Patrick? I am excited because I got out all of my bathing suits for us to look at tonight. So, all through the night... Oh! We still have to talk about who our special guest is. Now, I couldn't get a live appearance. I'm not that special. I don't have a check mark, would you say? But Brooklyn, grab one balloon. But I pondered to myself, who? What is the perfume? It's always my vanilla perfume. I'm wearing it, Jonathan. Nice to see you. Anyways, I pondered, who should we have tonight as our featured court? How could we make it even better? Who would love to hang out with us at a pool party? Well, I couldn't think of anybody better than Judge Middleton himself. Can you? We don't normally watch Judge Middleton around here, but I thought tonight we would do that. It is a party after all. So we'll do that. And Judge Ponytail, yeah, do you know the story behind his ponytail, John? Do you know the story? Judge Middleton is OG. You know, for the young kids out there, that means like original. He's one of the OGs of YouTube Court. I watched some of his infamous crazy cases back in the day when they first aired. But Judge Middleton quickly rose to fame, and so of course he can't be with us alone tonight. That probably wouldn't be good. I've heard he's married. That's not what I meant. But anyways, my whole point is that we are going to watch some Judge Middleton. But he stopped cutting his hair during COVID, and he said once he went back to like regular life, he would cut it. I'm pretty sure that was the story. Of course, I never remember well. I better be careful. Changing the angle here, dangerous move. Okay. You think he's a bit lenient? I would hazard a guess that we're about to watch some small town shenanigans happen. These are going to be, what are they? Let's make sure that they're the right thing, because where are they? Where are they? Hold on, please. There they are. They're, circuit zoning measures? I don't know why that would do a bunch of those, but Judge Middleton, thank you so much for joining me tonight. What do you got for us? We can't open a lot, I would hope.
Are the Yoders here?
Oh gosh.
Somebody filed something. Did you get a copy of this, Lance?
I did. Somebody handed it to me, but it was not the Yoders that handed
Oh,
it to me.
okay. Well, I just got it a minute ago, so. All right, well, it is the appointed time. It's 2:02. Let me call these cases. Get them set out here. There are matters in two separate cases before the court. Oh, yes, thank you. Everybody may need to scooch down.
Did you hear that in the back? Please scooch down. Please scooch
There
down.
are two separate matters before the court here today. And there are several things that we're going to need to address. The title of the cases, for starters, is Colon Township versus Joanne Yoder, which is 25533CZ, and Colon Township versus Alfred Yoder, which is 25533CZ.
Zed.
There is a preceding case, Township versus Alfred Yoder and Joanne Yoder, which is in file 252040 CZ.
Z.
In 25040 CZ, there is a permanent injunction in effect that was ordered by Judge Stutzman earlier this summer in July. And the defendants were compelled to appear at a show cause hearing, and they failed to appear. And Judge Stutzman issued bench warrants for their arrest. The way I read the petition is for civil contempt, set bond at $1,000 cash in each case. I believe last Friday, I found out about this on Monday. The defendants apparently presented themselves at the jail on August 22nd, posted $1,000 cash bond in each case, and were given a notice to appear for today for the show cause contempt in file 25040 CZ. Plaintiff Township has filed a brief in support of a motion for preliminary injunction, actually requesting a permanent injunction, and file 25533 CZ. These are two separate parcels of property. 25040 CZ is 30158 Marsh Road. I believe the property known as Mama's House, which has been in operation for some time.
Mama's house? Come on down to Mama's house.
Second case, 25533 CZ has the same addresses, but it is a different parcel of property very near the other property on Marsh Road.
It actually has a separate
All right.
address.
Adjacent to,
30246.
what is the number?
30246 Marsh Road is the 533 CZ case.
All right,
Now the Yoders live at 30158.
All right.
That's their address.
this is adjacent. All right, now preceding all of this, all right, we'll get a little background. This matter has been pending before Judge Stutzman, and he's had several hearings in this matter. Judge Stutzman is a circuit court judge, and this matter was filed for hearing in the circuit court. Judge Stutzman made some rulings and issued these two bench warrants. Sometime after the bench warrants were issued, I was assigned by the Supreme Court to hear this matter. Judge Stutzman has disqualified himself for reasons that are known to him. And he asked me, he actually called me while I was on vacation and asked me while I would take this case.
Were you in Key West?
And I said, yes, I would.
And yes, you
So
were.
Mr. Thornton has filed a motion to, I guess, reassign me or disqualify me under the theory that the matter should have been assigned to a circuit court judge. And so we have to deal with that before we deal with anything else. Once the order of disqualification was entered, Judge Stutzman signed it, Judge Pattison signed it. I don't remember whether Judge Kane did. I had already agreed that I would take it. Mr. Thornton, you're aware of this. St. Joseph County is part of a concurrent jurisdiction plan. That was entered on January 16th of 2013, and I'll provide you with a copy of that. And the concurrent jurisdiction plan indicates that the benches will share obligations. There is a statute, 600.8304. regarding jurisdiction. A district court, in a district court district, which the district court is affected by a plan of concurrent jurisdiction adopted under Chapter 4, the district court has concurrent jurisdiction with the circuit court or the probate court, or both, as provided in the plan of concurrent jurisdiction. So just before you folks all came in here, I did a personal protection order matter, and I've done dozens, maybe hundreds of them. Those are circuit court matters, and we are all cross-assigned under our concurrent jurisdiction plan, and all 4 judges actually do personal protection orders. And I do my share, and I had one just a few minutes ago. On a number of occasions, I have covered circuit court matters in criminal disqualifications. I'm the primary backup for Judge Stutzman if he has a case in which he has to disqualify himself in a criminal case. So those are felonies. I've handled a number of those. I'm also his primary backup in zoning cases. And he's had several occasions over the years where he's had to disqualify himself in zoning matters. He disqualified himself in Lockport Township because he lived very near where the property at issue was. Recently disqualified himself. He moved to Fabius Township. And they had a complicated matter regarding solar farm. And he was disqualified. And I was assigned by the Supreme Court and our chief judge to hear the matter. So Mr. Thornton has cited some of the case regarding that, but Mr. Thornton, I do not believe it would require that I not be eligible to handle this case. I'll ask you if you have any other comment, but it's my intention to deny your order to reassign a judge. What would happen is it would then go to the next judge, who would be Judge Pattison or Judge Kane, who would know even less about this than I do. But I don't feel like I know less. As you know, we do lots of zoning cases of all shapes and sizes. And so it's my intention to deny your motion, but is there anything else you'd like to place on the record?
I appreciate the court providing me with a copy of the concurrent jurisdiction plan.
Do you have one yet?
I do.
Okay,
I
yes,
do
so I think you
have
said that.
So not sure I agree with the whole concept, but I understand the law. I've read it and read the concurrent jurisdiction plan. I understand it, and I understand that it provides that this can happen. Before Your Honor actually rules, though, I would just like to inquire because it does appear that Judge Stutzman said he had a conflict. Judge Pattison has indicated he has a conflict, had some knowledge and or had spoken with the Yoders or their friends or both. On behalf of the township, I would just ask if Your Honor feels like there's anything that he knows or has been introduced to that would cause a conflict for Your Honor in this matter.
Well, that's a fair question. In the last case, I represented that I was going to dinner at Farron Hall shortly after our hearing. And that was an issue that I raised myself. The answer is no. I know very little about this. I was at a county commission meeting when a number of people got up and spoke at the commission meeting about this issue. And that was the first I even heard of it. I don't know any of the parties. I know very little about it. I have not discussed it with Judge Stutzman, other than when he called me and asked me whether I would accept the assignment. So no, I don't know the facility. I've never had a case involving Mama's house to my knowledge. I don't know Joanne Yoder. I don't know Alfred Yoder. Lord knows I would be more than happy to foist this off on another judge down the line, but I don't feel I have justification to disqualify myself. So for the record, I don't know the parties, know very little about the case. In fact, I was totally uninformed when the parties were at the commission meeting speaking about it, I asked my administrator, she had some knowledge of it. But, so the answer is no.
And I accept that, and so I'll just let the court make its ruling on my motions.
All right, I will do a formal order denying your motion in each case.
Tell me this is that. Seriously, tell me
So
that
that's
this
our
is a
first
real
order
strip
of
joint.
business. Our second order of business is to deal with the bench warrants. Because I didn't know anything about this case, I had to familiarize myself with the file. And so I spent some time going through both files, 25040CZ and 25533CZ. Things are mostly
Zed.
done in the 25040 case. Judge Stutzman entered the judgment of permanent injunction on, can't read it, March 13th, I think it was. So that case has been
That's somebody's
decided.
birthday that we know.
However, there was a show cause and then there was another show cause. And he issued 2 bench warrants. And then I was confused because the bench warrants were issued by Judge Stutzman and the clerk on, I believe it was July 7th. And the Yoders were personally served by Sergeant Morse from the Sheriff's Department later in July. At the time they were served of the notice for this hearing, they were open bench warrants for their arrest. And then a question of why weren't they arrested when they were served with the warrants? And I don't know that I got an answer to that. I don't think they wish to have a confrontation. I think there'd been some discussion about having them present themselves in the warrant, but a sheriff's deputy had personal contact with the defendants while the bench warrant was in effect, but it was not served.
My understanding is Bruce Morris doesn't conduct arrests anymore.
He does not, but he would. He doesn't. I don't want to. He does a wonderful job for us, as you
Yes, he
know. He
does.
handles our service, and he makes my life much easier by being so competent and professional. But at any rate, he is still deputized by the Sheriff's Department. Anyway, so eventually the Yoders presented themselves at the jail on Friday, the 22nd. We're given notice to appear today, and they're not here today. They posted $1,000 cash bond, each of them, and filed 25040. And there's a notice from the sheriff to appear today at this time and date, which is good because we were already scheduled to be here today at this time and date.
I wasn't aware that anything had been set for today for that particular issue, but
Yes, let me see. I think I copied the notices. They were given notice by I can't read the deputy's name. I guess I saw the original copy for August 29th at 1400 hours, failed to appear on the show cause. So they aren't here now. A number of other people are here. So I can't arraign them on their bench warrants because they aren't here.
This is my first bathing suit of the pool party. What do we think, Judge?
Someone
Sorry.
was here earlier this afternoon,
That's me. I'm Paisley.
and these were signed and date stamped August 29th. I received what I is entitled a response, in file 25040 and uh, 25533CZ. So the allegation is that the defendants were in civil contempt for failing to appear for an order to show cause. And now they fail to appear pursuant to a posted bond for an arraignment on the show cause. Mr. Thornton, what's your thought in that regard?
My thought first with the responses that have been filed today, as the court has pointed out in 25-040 CZ, there really isn't anything to respond to.
It's
in
dead.
that. So I don't know what the court wants to do with that. With the response today attempted to be filed in 25-533 CZ, the
Well,
orders are.
let's stick to 40 for a minute, because that's where the bench warrants are.
Okay,
I'm unhappy that they're not here. I never met them. I don't know them. I don't have any prejudgment about it. Judge Stutzman issued those bench warrants. There was criminal or civil contempt. My inclination is to issue a bench warrant for criminal contempt for failing to appear pursuant to a posted bond and set bond at none, no bond, until I see them. They will appear at the jail or be arrested by the sheriff and be held in custody until such time as I can conduct an arraignment. I don't like somebody poking me in the eye with a sharp stick. Judge Stutzman ordered the bench warrants. They did appear and present themselves. They posted $1,000 of cash in each case. Civil contempt is punishable by up to $7,500 in fines, but not a criminal punishment. Now they failed to appear pursuant to this. Now, this is a civil contempt in a zoning case. The Criminal Justice Reform Act changed the rules a little bit as to bench warrants in criminal cases. As a rule, we are to give 48 hours of grace before the bench warrant issues in a criminal contempt case. Fail to appear on a bond. And so my inclination, Mr. Thornton, is to issue 2 new bench warrants with no bond until they're seen by a judge, namely me. And give 48 hours. In fact, I would start the 48 hours on Monday. So they'd have until 5 o'clock on, well, Monday's a holiday. I would grant them until 5 o'clock Wednesday, September 3rd to appear.
and I'm fine with that, Your Honor. In that case, as the court's pointed out, we do have a permanent injunction. The birthing center is not supposed to be in operation, and it's my understanding it is still being operated.
Oh, it's fucking not a strip club. It's a birthing center. Hey, touchy subject. Touchy subject. Not what I was really interested in. Not a case I thought I would think judge. No, it's not that. I think it's birthing. It's the Amish are birthing. Like probably allegedly unlicensed midwives. But I don't think they're doing the abortions. No. Maybe. Anyways, let's continue. Judge Middleton, this case is took you a long time to get here.
We haven't taken any testimony regarding that, but that would violate the permanent injunction and subject them to further contempt if it is still being operated. Anyway, I'm gonna issue a bench warrant for Alfred E. Yoder for failing to appear pursuant to a posted bond and a contempt matter. I'm gonna set the bond at no bond until such time as he sees the judge. He has until Wednesday, September 3rd, to present himself at the court. I would order the exact same matter and Joanne Ann Yoder. I find she's in contempt for failing to appear at this hearing. It's not accidental contempt, it's willful contempt. They don't recognize the jurisdiction of the court. We have a fundamental disagreement on that subject. But if they don't appear this time, they're gonna sit in jail until such time as I can see them. So one for Alfred E. Yoder, one for Joanne Yoder. All right, so that finishes 40 CZ, 2540 CZ. That's the case that's done with a permanent injunction. That's on Mama's house. That's the bench warrants were in that case. The other case that it needs to be addressed today, which was set for hearing, is 25533 CZ. That is the other property where something was being constructed, I believe, to supplant or replace the facility that was used for Mama's house. The lawsuit was filed on July 22nd of 2025. The defendants filed no response. We'll talk about today's response in a minute. And the clerk sent out a notice of entry of default on August 22nd. They waited 31 days rather than 21 days, sent out a notice of default. So the matter was set for hearing today. They did not file a response in a timely manner and would be subject to the entry of a default granting the relief requested by the township. I received today in that case something entitled response. I read it. I'll accept it for filing. It doesn't meet the standard of a legal answer to a civil complaint. It's got some archaic language. It's got a fingerprint.
May I speak on that?
Yes.
Being in default, it's my understanding under the court rules that an answer cannot be filed and accepted by the court until the Yoders would file a motion and show a meritorious defense through affidavits or testimony.
Well, what we're gonna do, I'm gonna grant your default. Now that we need a default judgment. The entry of the default is in there. What we would need to do is. Yes,
After that guy, was that filed in my office?
it was stamped by Gina Evers.
I don't know if it was filed.
And it doesn't. I wanted to make sure that it wasn't, it's titled a response, so my clerks would not have put it in as anything other than a response. So I would not have used that as an answer.
In district court, we're much more flexible. We take handwritten answers, as you know, in civil stuff and grant the people a day in court. Well, this, whatever it is not filed in a timely manner. So we have a notice of entry of default signed by the clerk on August 22nd. What I need for you to do is move to enter the judgment of default as to each defendant. Your pleadings in that case. Now, the motion for today is for entry of a preliminary injunction. And you did a good job in your brief of setting out the standard for preliminary injunction and what it is. And it's not to be granted lightly, but it's based on the likelihood that the plaintiff will prevail in the ultimate hearing. In your actual motion, that's filed with the court, the relief request that on page 9, you request permanently enjoining the defendants, agents, servants, assigned successors in interest, or those active in ANSIC concert or participation with them from using the subject property as a birthing center. This is the adjoining property. So the complaint requests a permanent injunction. They have not responded to that in a timely manner.
I can address this, Your Honor.
Yes,
What I'm going to request today is that pursuant to Court Rule 2.111 E1, the detailed allegations in the complaint, and they are detailed, are now admitted by the defendants due to the default. And the defendants cannot proceed under with the action until the defaults are set aside under Court Rule 2.603A3.
and I agree with that.
And
So what we need to do is your pleadings stand as accepted because there's been no answer,
So
which
what-
would, and your pleadings include your signature as attorney for the township. Once we enter the judgment, and you're asking for the permanent injunction,
well, I was asking today for the preliminary injunction to be entered based on the fact that they're not here to defend, they're in default, and all those, the allegations in the complaint and the supporting documents are at this point admitted by the defendants. What I intend to do then is, let's see, provide under 2.603B1 of the default court rule. I may not be required to do so, but on the just being overly cautious, I will prepare a permanent a default judgment with permanent injunction, which I have not done yet, but will soon. And I would submit that, send notice to the Yoders, and then set that for hearing and have the court enter it at that hearing.
all right, so what you're asking me to do by default today is enter the preliminary injunction.
That's correct.
All right, I will so order as requested.
And Your Honor should have a proposed preliminary injunction order.
I have the brief and I have the judgment. Let me see if I have the order in here. Do you have a copy?
I do.
By default, the court finds that the defendants failed to file a response in a timely manner to the lawsuit, which was within 21 days. They've also failed to appear at this hearing, which also subjects them to default. This is the 29th day of August. This preliminary injunction order states the court makes the following findings. I'm gonna have to change the name, but Colon Township is likely to succeed on the merits of its claim against Alfred E. Yoder and Joanne Yoder with regard to the alleged violations of Michigan's construction code as cited. Defendants are the owners of the
Thank you. This is a bathing suit. We're at a pool party after all. I've been wearing bathing suits. It's not exactly practical for swimming, and I actually think it's becoming too big for me. Who's excited about that? This girl. Anyways, but it's cute nonetheless. It's like butterfly bathing suit, you know? Swimming, swimming in the deep blue sea. You can still see my titties. Be careful, Paisley.
following describe real property, and that is the subject of this case. And the property is described by legal description in the order. It's also known by a common address of 30246 Marsh Road, colon. A building being constructed on subject property without building permits and inspections by qualified building inspectors represents a dangerous situation that could easily result in irreparable harm to persons using or visiting the building, including emergency personnel. The court does lots of these. Routinely, we have zoning violations where people are building things without a permit, garden sheds, additions to their house, garages which are in the right of way of the road. That's routine zoning matters we do in the district court. I'll continue to quote from the proposed order. The plaintiff has no adequate remedy at law. The risk of harm that would exist if the preliminary injunction were not granted outweighs the inconvenience to the defendants caused by granting the injunction. The public interest is furthered and not harmed by the granting of the preliminary injunction. The applicable law cited in plaintiff's brief and support motion for a preliminary injunction authorizes injunctive relief under the circumstances. And as I mentioned, Mr. Thorne filed a brief which was well cited with the facts and the law. It is hereby ordered that the above finding facts are hereby, the above findings of fact are hereby incorporated and made a part of this order. Plaintiff's motion for preliminary injunction is granted. The defendants and their officers, agents, service employees, attorneys, assigns, successors in interest, or anyone in active concert or participation with the defendant are enjoined from performing any further work on the interior or exterior of the building being constructed on the subject property unless a valid building
3 months. Oh my gosh, it's going away. My bathing suit. Not today. Please, baby. Thank you for 3 months. I can't tell what your picture is. And the names are all fucked up. But no, I love you anyways. No matter what. Yet another bathing suit. I know, it's like, oh, it's because part of it's striped. And I think it's picking it up. Oh my goodness. Oh my gosh. I don't have big boobs and they just look like it. Well, I guess they're sort of big. Anyways. I guess I'm gonna have to change out of this one pretty. Oh, see, like, you can almost see it and then it's like, bitch. We're turning that off. Oh, I guess I maybe could fix a body painting bathing suit. I don't. Those don't have much tummy control. Talk to me in 6 months. Oh, the right one is way bigger. No, the left one. This one. Bigger. The right one's smaller. But my right. My left. The more you know. Wrong tune. Jesus Christ, Paisley.
permit is issued for the building by plaintiff's building code officials, and the stop work orders that have been issued and posted are rescinded by the plaintiff's building code officials. And occupying the building on the subject property or allowing anyone else to occupy the building unless written authorization to do so is obtained from the plaintiff's building code officials. Colon Township shall cause a certified copy of this order to be posted on the front door of the building of the subject property within 10 days of the entry of this order. And no one shall remove the posted copy of this order from the front door unless and until its removal is authorized by the plaintiff building code officials. This order will remain in full force and effect until this court specifically orders otherwise. This property is posted, and there's a copy of it in here with a prominent.
No. First of all, thank you for 17 months, and that's a fair caveat for judging bathing suits. And do you think they're ugly, Brooklyn? You don't like my bathing suits? What about the first one, the black one? I still have one more. I still have one more to try on. Judge, I barely know what you're talking about, but thank you for holding down the court today, or the fort, so to speak. And thank you, Billy Buzz Smith, for 20 months.
No trespassing sign. And arguably posting this on the front door of the property. So you may post this on the trespassing sign.
Right.
So you
And
won't have
Shane,
to
10
enter onto their
months,
property
thank
over their
you.
objection. There's a trespassing sign of some elaborate detail in front of the property.
Or would the court entertain adding to my order that we be permitted to go on to post it on the front door with a.
Well,
peace
it already
officer?
says that, but I don't want a confrontation.
Well, I would request a peace officer from
All
the.
right, well, then I'll leave it as you've drafted it. Signed effective August 29, 2025. This order is entered by default. Failure to answer in a timely manner and fail to appear for the hearing. And Mr. Thornton started to speak to this. When a default is entered, the plaintiff can move to have the default set aside. I believe it's within 21 days of the entry of the default. And in order to do that, you have to show good cause for failing to appear or answer, and you have to show an affidavit of meritorious defense. And this comes up all the time in my court. Late people are being sued by an insurance company or a hospital or an auto lender, and they get defaulted and they don't understand what's going on, and they file an answer in a handwritten letter, but it doesn't rise to the level of the statute to set aside a default. You need just cause for failing to appear at the hearing, and I don't know what that is, because they aren't here, and as I said, I'm not very happy about that. And secondly, they have to show an affidavit of meritorious defense. The document entitled the response, I make no finding on whether it is an answer, appropriate answer. Whatever it is, it isn't filed in a timely manner. And secondly, they aren't here to address it. You don't swing by the courthouse 5 minutes before the hearing, drop off a vague pleading and cover your bases. That's not how it works. They were willing to present themselves on the warrants and post the bond. So I'm disappointed that they aren't here. I had hoped to engage in some sort of dialogue. In true point of fact, they need a lawyer. They need a lawyer who's licensed in the state of Michigan. They're going to end up in jail. there may be legitimate defenses to this. There may be issues that could be explored by competent counsel. They have their own reasons for choosing not to retain counsel and be represented by themselves. But in the humble opinion of this court, they could benefit from competent legal advice because they're going to end up in jail. They're going to end up in jail unless they appear by next Wednesday at 5 o'clock, because they're going to sit in jail until I get a chance to see them. They were ordered to appear by Judge Stutzman. They failed to appear twice. He issued a warrant for their arrest. They were given a notice to appear today, and they gave me the same discourtesy they gave to Judge Stutzman in failing to appear. So I can't even talk to them. So let's recap. I've denied the township's motion to disqualify myself because there is a concurrent jurisdiction plan in place. I handle these matters in my own court routinely. This is not outside the province of cases that I regularly do. So I'm going to do a written order denying that in each of the two cases. Secondly, I intended to arraign the defendants on the bench warrants in 25040CZ, but they failed to appear. So I issued new bench
Zed.
warrants with no bond. The defendants are allowed 48 hours, in this case, a little more than that, until next Wednesday at 5 o'clock to present themselves either at the jail or at the court. The bond is none. Third, I've granted plaintiff's motion to request a preliminary injunction and filed 25533CZ. Mr. Thornton intends to
Zed.
file a further notice asking for a
Don't say
permanent
pasta, I
injunction,
want it.
and again, giving them an opportunity to respond. But until further order of the court, the preliminary injunction is in place to prohibit any further construction or occupation of the second building. Mr. Thornton, is there anything else we need to do here?
No, I will see the court, your honor secretary, about getting a date for the next hearing for that proposed default judgment.
All right, very good. It's easier than it was with my schedule, vacation schedule, the judicial conference. We're good now till deer season when Judge Pattison is gone much in November, but we're here for the duration, so it should be easier to find a place to put
Could
this
you
than
get more
what we had for
Michigan
today.
than that?
Okay.
All right, this is a public courtroom, and I appreciate that. This matter is also being live streamed. You can watch it on YouTube. It's important to have a public courtroom that people can come into and sit and see what happened. You just saw what happened. You may not agree with it, but it wasn't done in secret. So we'll see how we proceed further. Thank you all for being here today and your decorum.
Thank you, your honor.
I've signed the order. The clerk will prepare it, and I'll do my other two orders denying your motion to disqualify.
Yeah, I'll
Prepare the bench ones too.
What's that?
You're gonna prepare the bench ones.
Yes, we should make that. I'd ask you to prepare the bench warrants as the last.
Okay, okay, I will do that.
Oh, we're back in the pool, Judge. Thank you so much. That was actually very interesting once I realized what's going on. So, turns out allegedly there's a group of people running a birthing center on some property within the township. Courtney, I wish. But I wore how many different bathing suits? If we were at a pool party together in real life, you might only see me in like 2. I always have a change of outfit with me. Thank you guys so much for being here. I understand that it wasn't a real pool, but together we were in the pool in our hearts. And that's what matters. I really appreciate each and every one of you. Thank you for making my day special. I love that. The only thing that could make it better is if we could all go out to eat together, sit down, eat a meal, have a lovely night. One day we'll do that. Anyways, do me a favor. In the meantime, remember that I love you and I'm proud of you. And I will see you in the next video. Okay, bye. I know, it's September tomorrow. Shh, don't tell anybody. Bye.
Ways down the